Members to the 17th meeting in 2013 of the Subordinate Legislation Committee. As always, I'll ask members to turn off mobile phones, please. Agenda item 1 is a decision on taking business in private. It's proposed the committee takes items 6 and 7 in private. Item 6 is consideration of the evidence we're about to take on the Regulatory Reform Scotland Bill, and item 7 is consideration of the evidence we will take in a few minutes on the Children's Hearing Scotland Act 2011 Rehabilitation of Offenders, Transitory Provisions Order 2013 SSI 2013-146. Do members agree to take these items in private, please?
Agreed.
We do, thank you. Which brings us straight to agenda item 2, which is the Regulatory Reform Scotland Bill. And this is an opportunity for us to ask questions of the Scottish Government officials on that bill. I welcome from the Scottish Government George Burgess, Deputy Director for Environmental Quality Division, Joe Brown, who's the Head of Better Regulation and Industry Engagement, Enterprise and Cities Division, and Stuart Fubister, who's there as a Divisional Solicitor in the Directorate for Legal Services. Good morning, gentlemen. It's very good to see you. Can I ask, firstly, if you could give us a background, please, to parts 1 and 2 of the bill, in particular how, in broad terms, it will change the powers to make subordinate legislation on regulatory and environmental matters compared with those that are currently available. Who'd like to?
In broad terms, I suppose the background to part 1 is to allow to promote consistency in regulation across Scotland, and to empower regulators to consider economic considerations, to take into account economic considerations in their in the performance of their duties, in addition to the other statutory functions that they have. So there's an element of equity there. We will therefore have what we're proposing to take as powers to bring forward regulations which would, I suppose, represent national standards of regulatory practice in areas yet to be identified.
National standards therefore displace all other standards at that level?
At this stage, it's hard to say. I mean, there is one proposed national standard elsewhere in the bill where we're suggesting that we will introduce a national standard for, I suppose, the licensing arrangements for mobile food vans, and there's a food safety element to that we're working on with the Food Standards Agency. So that is quite a narrowly focused example. We're also working with COSLA currently to identify a range of proposals that they can come forward with in terms of regulatory functions that they believe, where they believe national standards could be introduced. But I don't yet have those examples to present to you. The other examples that I suppose that came forward in terms of our consultation processes related largely to other aspects of licensing undertaken by local authorities, whether relating to alcohol and a range of other things.
Right. I'm just reflecting on your opening sentence. At least as I heard it, in the suggestion that would provide consistency. I'm just trying to establish whether that's a consistency for a particular area of business across the country, or whether that's a consistency for all areas of regulation within Scottish law.
It's more the former. I would suggest that we would be looking to, I suppose, address some of the issues that are raised with us by particular sectors or of business communities in relation to, I suppose, the regulatory experience that they have. So it's to sometimes, I guess, it will be about the regulation and a sort of truly national standard, and sometimes it will be about the processes that underpin that, so that I suppose the example that we had frequently in the context of the consultation was alcohol licensing, where there's a range of different forms and requirements imposed, I suppose, by different local authorities, and looking back at the original legislation, actually there doesn't seem to be a particularly good explanation for that. So a consistency in terms of the process that businesses would go through could be another example that emerges from this.
Somebody, Stuart, did you want to come on?
I just wanted to pick up on the opening remarks, Mr. Brown, and get clarity as to whether this bill creates the powers for one or more of these bodies currently listed in the bill, and of course it could be more in future, to take economic issues into consideration. Can you point the committee at any of the bodies currently listed which are not permitted to take economic issues into consideration? Or is this merely a convenience?
The evidence, I guess, that we've had presented to us suggests that while great strides have been taken in terms of I suppose the way that these public bodies align themselves with the Scottish Government's economic purpose and promoting economic development, that it's not applied consistently in every respect.
Can I just come in over you? I'm not anxious to explore the policy issues, okay, because that's not the remit of this committee. I'm simply, we're quite technical in the approach we're going to be taking today. And I just simply wanted to know, because you focused, you specifically, if I heard you correctly, seemed to say this would enable bodies for the first time to take economic factors into consideration in making decisions. And I just wanted to be clear if you were able to point to a body where at present they are inhibited from, in their decision-making processes, taking economic issues into consideration. And I ask that question simply so that we understand the scope of the technical detail, and in particular in relation to subordinate legislation, our particular interest, that this will cover.
My understanding is that all of the bodies there, individual regulators can have the discretion to take economic factors into consideration in terms of the decision making. However, equally they have the discretion not to. What the bill is intended to do is to provide equity parity, so that regulators make a balanced consideration of economic and other relevant factors in determining the decision and are held accountable for that.
Okay, so that's economic factors. What other things are we trying to standardise?
Well, it would relate to the specific functions of the regulator. I mean, if the regulator is dealing with environmental or heritage or food safety or a range of other issues, then they would normally also have statutory requirements to consider those factors.
Under this bill?
Under the existing legislation that covers their roles and their functions.
Do forgive me, I may be being, it's early in the day and my brain may not have woken itself up yet. It does seem, therefore, that the bill boils down to the very slight thing of enabling ministers to apply a national standard to a range of bodies in their decision-making. Is that the substance of what actually looks a rather bigger bill than perhaps that would suggest?
Section 1 addresses the economic considerations and national standards. The bill is a composite bill, as you'll appreciate. So I wouldn't necessarily endorse that description of it.
Well, I invite you to express it another way then.
Well, it certainly what it's intended to do is allow us to deliver greater consistency through national standards where appropriate. empower regulators to take economic factors into the decision-making process.
Which they can.
Yes, yes, but to do so.
I'm just wondering if we can move on to John. I'm sure we can return. I think we've got your point.
Okay.
John, can I invite John Scott to take the questioning forward? Thank you.
Thank you very much, Chairman. In terms of consistency, and just perhaps going to a more straightforward question, can you explain how the Scottish Government has ensured that an appropriate balance has been struck between primary legislation and the powers to make subordinate legislation, taking the Bill's policy objectives into account? Please.
I can speak in regard to Part 1. Part 1 is almost wholly subordinate legislation, because what it does is give us powers to, as Joe has mentioned, set national standards. There isn't anything definite in that field yet to be put down in primary legislation, so we have proceeded entirely by powers as far as Part 1 is concerned.
Could I just observe, I think we've divided our questions up essentially into Part 1 and following, and I think we're on Part 1 at the moment, so I think if you could be clear about that, that might help the discussion.
Yep.
Yeah, thank you.
Thank you. That's Part 1 to which I was referring. Paragraph 19 of the Delegated Powers Memorandum gives us the reason for the powers to make regulations in connections with regulatory functions, that it will provide sufficient flexibility to enable measures to encourage or improve regulatory consistency to be taken quickly and efficiently in response to changing circumstances without resort to primary legislation. However, the memorandum does not seem to explain or give examples of how these powers might be used in relation to the regulators listed in Schedule 1. Could you explain the intended effects of the powers on these regulators and perhaps give us some examples? In as much as you haven't already done so, to Stuart Stevens.
I suppose perhaps the best example is the example of a national standard that is in the bill, and that I've referred to that already, where in relation to mobile food vans, we're introducing a different protocol. What that will do, or let me explain, I guess, the sort of policy background and where the issue, where the problem came from, and then how we're attempting to address it. So we, through business representation, we established that there were, across all of the local authorities in Scotland, two different approaches being taken to the examination of mobile food vans, to assess whether the equipment, the kit in the van was sufficient to support food safety. When we discussed the two policy approaches that were in place with environmental health officers, there was agreement that this wasn't a particularly helpful situation, because it created some issues in relation to where food vans were operating in a range of different local authorities, and therefore had different requirements which seemed to be arbitrarily imposed upon them. We also confirmed that the food vans had to be inspected by each local authority. So working with the Food Standards Agency, we are working towards the creation of a common, consistent standard of kit, which we are expecting to be delivered by them in December of this year. The bill will therefore allow, or will address that, create a common, or building on that common standard. The bill will allow us to, I suppose, eradicate the practice of multiple examinations or inspections by local authorities, so that we will put in place, I suppose, the condition that a mobile food van will go to the local authority in which the business is registered, and will be inspected against the common standard. If it passes, it passes. If it fails, it then has remedies to go through. That certificate that it receives from the local authority in which it's based will be recognised through the bill by all local authorities in Scotland, and therefore means that local authority, the food vans themselves have clarity and consistency in terms of the equipment that they're required. It means that they will no longer have multiple inspections.
Forgive me, that's fascinating, but I do need to remind us that we're not worried about the policy. I can see the point, and I think we can all see the point, but we're not sitting on that committee.
Okay.
I think the concern is about the balance of how we're proposing to legislate between primary legislation and subordinate legislation, the flexibility that's inherent in that. I think we've got the example. Yes, thank you. But we don't actually have to worry whether that works, because that's not our problem.
Right.
Forgive me. Thank you. John, do you want to pursue that? You're comfortable with?
Yep.
If I could just do a tiny wee bit of clarity, technical clarity. So if a food van company is registered in Carlisle, which council does it?
In Carlisle?
Yes. Because of course it could be trading across the border.
I'd have to.
No, I mean, I'm just, one of the arguments that's being deployed is there should be consistency in the national standard, and I just leave that thought with you, perhaps.
Yes, absolutely.
Okay, let's leave that thought there. If John's happy, can we go on to Mike, please?
Yeah, it's really just picking up this same theme in kind of broad terms. And I wonder if the government's considered if there are any legislative provisions setting out significant regulatory functions of a body listed in the bill, or any other bodies that might be added in the future, when it might be more appropriate to retain scrutiny by primary legislation. Stampede to answer. Anybody could, it's not necessarily you, Mr. Brown, anybody that wishes to answer, please pick it up.
I think, as I say, the premise for this section of the bill is to enable us to respond to the issues that are raised either by regulators or by businesses in terms of practical examples of problems that they are experiencing, where national standards may allow a better balance between, I suppose, the.
With respect, I think we've really more than adequately already answered that. And what we're talking about here is the balance that's been struck between primary legislation that's subject to full parliamentary scrutiny and subordinate legislation where the level of scrutiny is perhaps not as great. And in considering that balance, how did you, how did you weigh that issue of scrutiny?
I think the weight, the balance would fall on the fact that we were hearing consistently from business organisations that I suppose the way in which regulatory activities were being carried out were not always as supportive to businesses and economic growth as might be in the best interests of the economy. But that we didn't have, we had some examples, but not a whole host of examples of various specific areas in which this could be brought forward. So it's allowing scope for that, for these examples to emerge organically from the business community and or regulators themselves.
So that you're, I'm still not quite with you in as much as you seem to be talking to a certain extent about policy rather than the legislative mechanism, but perhaps I'll maybe move on to my next question, and it's to ask really if the government have considered if any functions of the regulatory bodies listed in the bill, or which could be added again in the future, are not appropriate to be regulated by Scottish ministers. For example, where local authorities have a level of independence from the Scottish Government.
I'm not aware of there being any specific issue there. We have spoken at length and engaged COSLA throughout the process of developing the policy. Sorry to return to that, but COSLA have expressed some support for the bill, albeit in particularly moving forward following consultation. They haven't raised that particular issue with us.
The affirmative procedure applies to the powers to make regulations in Section 1. Can you explain why this level of scrutiny is deemed to be appropriate in Section 1?
Simply because the powers are very wide-ranging. They allow a fair amount to be done by way of setting national standards, rather than try and separate out more minor matters that could have been covered by negative resolution regulations. We felt it better just to apply affirmative to any provisions made by way of Section 1 regulations.
Okay, thank you. And that brings me on to my next question. In Sections 2, 1 and 2, the powers included to create a new regulatory requirements. And as the potential scope of such powers is uncertain, was consideration given to applying a higher level of scrutiny, such as super affirmative procedure, for the creation of new regulatory requirements?
No, not specifically to that.
No. So you don't feel under those circumstances that might be appropriate?
No.
Can you explain why not?
Super affirmative is a provision that is very rarely used.
But
I would not see the issues here as being major enough to justify
even when
form
entirely
of procedure.
new regulatory requirements are being created.
Still a regulatory requirement. It's not at the top end of what we would normally consider as appropriate for a super affirmative.
Okay, thank you.
John, do you?
I'm fine. Yeah.
Yes, I think you're back on, please, John.
Do you want me to go on to Section 4?
I'm looking at section. Yes.
Okay.
you.
And that's, as you will know, about power to give guidance to regulators as the carrying out of the duty described in Section 4.1. And my next question is, Section 4 provides for ministers to give guidance to regulators in relation to their duty to contribute to achieving sustainable economic growth, as we've already discussed. Can you give further explanation as to how the Scottish ministers intend to use this power and how it could affect the regulators listed in the bill?
The expectation is that the principal source of guidance will be the code of practice that is identified in Section 5 and 6. We were alert, however, to the potential that regulators themselves may or others may raise ad hoc issues which ministers could give guidance to, and it was that expectation that we were that led us to include that advice giving power in the legislation or in the draft bill. The expectation, as I say, is that the code of practice, which we are in the process of developing, will be, I suppose, an evolving document over time, and will, I suppose, assimilate points which emerge through policy development. But it was the capacity, I suppose what we're keen to retain is the capacity for ministers to give guidance where it's required by regulators on to ad hoc issues.
And given those circumstances you described, can you explain then why it was deemed appropriate not to apply any procedure to this power? Maybe one of your colleagues want to pick that one up.
I think simply for flexibility, as Joe has said, the main document would be the code of practice, and we would expect to see most things in there. And it could include the subject matter of what could end up, what could alternatively be put as guidance. But particularly with regulators perhaps coming to us, the Scottish ministers, and looking for further guidance, the ability to do that quickly without any parliamentary procedure we thought was useful.
Is speed entirely of the essence here? I mean, it seems to me that scrutiny is also important, and you're denying a level of scrutiny of any sort. Are you not?
There is no parliamentary scrutiny on it. It is fairly limited. It is a power to give guidance as to a statutory provision. We obviously can't give guidance that in any way falls outside the law. The ambit of what can be done under Section 4 is a good deal narrower than what can be done under the Code of Practice in Section 5.
So we should be reassured that there's nothing for us to be concerned about in terms of this exercise of power without any parliamentary scrutiny.
We would take that line, yes.
Yeah, interesting.
I'm wondering if I could just follow that up with the rather obvious question that can't ministers do that at the moment anyway? Particularly if a body comes to the minister and says, "What do you do with this, please, sir?" They're going to listen to the answer. So why does the minister need a power to give that guidance?
The power is in the requirement on the regulator to have regard to it. Admittedly, if a body specifically requests some sort of guidance from the Scottish ministers, then we can do that without legislation. But the teeth in Section 4 is that any guidance given, the regulator must have regard to.
Give me, so just so that I can get it clear in my head. So at the moment, what you do in these regards has to be done under legislation. Now it will only be done in terms of guidance.
No, I think what I was saying was that at present, if there's no legislation in the area and a body wants to know what the Scottish Minister's views are on interpretation of statutory duty, that can be offered. I suspect it would usually also be offered, if it came anywhere near lawyers, as saying, well, this is a Scottish Government view, but it carries no particular weight. You have to take your own legal advice. Here, we go a bit wider. We take a power to give guidance and say effectively that the regulator must have regard to that.
But Parliament there's no input into that.
Not under current drafting of the bill, no.
Okay, thank you.
I have to say, I think we're now getting somewhere near something which I actually, I quite like that answer, if I may say so. Something that stops two groups of people from having to take legal advice seems to me to be an extremely good idea. Right, on we go then. I think we've now got to part 2, the environmental regulation, and Mr. Stevenson will take us through it.
Thank you very much. An opportunity for Mr. Burgess, I'm sure, to contribute to our deliberations. The Delegated Powers Memorandum at paragraphs 34 and 35 talks about the powers to make regulations, protect and improve the environment as a simplification and rationalisation. However, I note that in Schedule 2 there is a considerable list of matters that could be included in the regulations, such as specifying other activities as environmental activities, specifying them as environmental activities, I think, for the first time, and then regulating them. Could you perhaps resolve in my mind the tension that there appears to be between the claim in paragraphs 34, 35 of simplification and what's in Schedule 2, which by giving a pretty wide power to ministers to expand the remit of environmental regulation how that could be seen in any meaningful sense as being simplification or rationalisation.
Okay, to deal first of all with the question of simplification, at the moment most of our environmental regulation, the main regimes, so covering industrial pollution, waste, radioactive substances and the water environment, come from a variety of statutes of different vintages. It's a really quite complicated mixture of primary and secondary. So perhaps going back to some of the question asked in relation to part one, what we have for waste is quite a bit of detail in the primary legislation and also quite a bit of detail in the secondary. Radioactive substances is from an Act of 1993, but essentially a consolidation from the 1960s. Almost all of that is set out in the primary legislation and causes difficulties for SEPA and operators to try and fit the practices that they're seeking to regulate into the framework set out in that primary legislation. Most of our industrial pollution and prevention and control legislation is dealt with under the Pollution Prevention and Control Act 1999 and the water environment under the Water Environment and Water Services Scotland Act 2003. Now the 1999 Act that I mentioned actually has a very broad power, not dissimilar to the one that is provided here, allowing essentially ministers by regulations to regulate activities, essentially activities of any nature. So we already have in statute a very broad power in the 1999 Act, and that's indeed is the power that our colleagues south of the border have used to bring together all of their regulatory regimes for water, industrial pollution, waste and radioactivity. That power and the one that we've got in the bill is actually quite closely modelled on that, has a fairly detailed schedule of the matters that can be contained in the regulation. So in that sense, what we provided in the bill is nothing new. It doesn't go any wider than the existing powers in the 1999 Act. What is different, though, is that the Water Environment Water Services Scotland Act 2003, specifically for the water environment, provides for a much more proportionate scheme of regulation. So depending on the significance of the activity, it can be regulated at the level of a licence or at a registration or simply under general binding rules. That is a sort of flexibility and proportionality that's absent from the 1999 Act. So with apologies to official report colleagues if I wave my hands in the air at this point, we're taking the sort of broad horizontal approach from the 1999 Act of being able to cover a wide range of environmental activities, but where all you can do is apply a permit, and the vertical approach from the Water Environment Water Services that you can apply a much more proportionate level of regulation, but in a narrow area, and we bring those two together to get this new framework, which I sincerely hope will be quite a bit simpler and more flexible to operate for all concerned.
I think that's encouraging as a description, but I wonder if it meets the test of simplification if, as you suggest, the 1999 Act still draws upon a 1960s Act in relation to radioactivity, and furthermore, this new Act does not draw into itself all the powers in relation to this that are in the 1999 Act and the 2003 Act. Would it not be possible to argue, therefore, that you are merely spreading the legislative levers that are available across a further Act without dispensing any previous Acts, and hence the word simplification is not the most obvious one to use?
It certainly is an attempt to simplify, and we are actually in the bill removing the power from the 2003 Act under which the controlled activities regulations are made there. It would be our intention, if at all possible, to do away with the power in the 1999 Act. There are some complications of legislative competence in relation to that, because it is not entirely devolved, and that Act is also used to regulate industrial pollution from offshore activities, which is not within the legislative competence of this Parliament. So while our intention is certainly to replace everything that is regulated under the 1999 Act and the 2003 Act with new regulations under this power, our ability to completely sweep away those earlier schemes of regulation is more limited. It would certainly be our intention as well to use this power to replace the regime for waste that is contained in the Environmental Protection Act 1990 and the Radioactive Substances Act 1993, which is the one that I was mentioning is based on the 1960s model, so that we do get a single set of regulatory procedures rather than have, for instance, appeals provisions scattered across several different pieces of legislation and not all saying the same thing.
Well, given that you've indicated there are some various issues around this, and that the government may seek to draw these into Scottish legislation, has the government had discussions with the UK administration to get, I think it's a Section 103 order, if I recall correctly, so that such matters can be dealt with within the scope of this bill?
I'll raise you one. It's a Section 104 order. The issue in particular is around regulation of energy efficiency, and so far as that is dealt with under the 1999 Act, that is already executively devolved so that the Scottish ministers can use the power, as most recently was done in the Pollution Prevention and Control Scotland Act regulation.
For clarity, for those who may be reading this, can you confirm to me that executive devolution means that Scottish ministers may exercise the power, but the Parliament may not legislate in the area?
That's correct, although the power that was executively devolved was the power of the Scottish ministers to make regulations in this area. So that power has been exercised in the Pollution Prevention and Control Scotland Regulations 2012, just at the end of last year. So there are some complications in there around precisely what we can regulate. The offshore regulation probably would not come in at any stage to this, but so far as possible we are indeed seeking to simplify matters and get rid of the earlier regulation schemes.
Let me just end by returning, in the context of environmental legislation, to the issue that we covered in part one, which is the balance between primary and secondary powers being exercised, with in essence everything that matters being delegated to secondary powers. Given that when we have secondary power, that removes from Parliament the ability to amend legislation, which only comes when we consider primary legislation. Is the government committing to be flexible in its withdrawal of instruments and replacement of instruments if Parliament has serious views about the structure and policy scope of secondary legislation? In other words, given that it's all going to be secondary, are we going to be able, as a legislature, to adequately influence the development of environmental legislation through the secondary legislation mechanism?
I'm sure ministers would always be cognizant of any views expressed by committees of the Parliament, whether this one or the subject committees. However, I would certainly see that as very much the backstop throughout the whole process, and this has been a partnership project between ourselves and the Scottish Environment Protection Agency. there have already been a number of consultations as the proposals have been developed. So lots of opportunities for interested parties, regulated businesses, NGOs, and others to get involved in the process. So I think for me, certainly, the prospect of getting a set of regulations before this Parliament that suddenly, there is a deep concern about a fundamental aspect of it, I would see that as a significant failure on our part if we ever found ourselves in that position. So I'm sure, were there to be any concerns from the Parliament, ministers would deal with that appropriately at the time. But certainly the approach is to consult with people as we develop the detail of the regulations, and so that everyone is actually content with it. I think as well, if we look at the history within this Parliament of scrutiny of regulations under the existing 1999 Act power, I mentioned the set of regulations that were passed at the end of last year, and there was a brief debate within the committee because those were taken under affirmative procedure. But I happened to look back at the original set of regulations dealt with in 2000, so the very first set of regulations under that power, and they went through the committee on the nod. John?
And in that regard, I think Stuart Stevenson raises a very valid point, because bringing forward legislation in this way by means of subordinate legislation, and most often I would suspect negative instruments, this committee at any rate has little or no ability to scrutinise the policy issues. And yet, nonetheless, if the instrument is technically correct, as you say, it will go through on the nod here, as you well know, and the committee who might consider the policy issue will just say, oh, well, the Subordinate Legislation Committee, quite happy with it, next. And I just feel there's a gap there, there's a sort of crack in the paving stones opening up where things could slip through without possibly adequate levels of parliamentary scrutiny. But I would just want to be further reassured by you that that couldn't happen, that somehow or other I'm being naive.
I'm inclined to say trust us from government, but that might not be the answer you're looking for. I mean, certainly given the example I've just given of the PPC regulations, the more recent scrutiny of those of that regulations under that power was certainly more detailed than back in 2000. What essentially we're asking Parliament to do here is to give ministers a power. It is, as members have said, a broad power, but it's also a quite clearly expressed power in terms of the detail that's provided in the schedule to the bill of what can be done using that power. It's also in an area that is, as I say, quite well precedent. We have already existing sets of regulations using very similar powers. So Parliament has already seen the sort of thing that ministers would do under those powers, and as I say, combined with adequate consultation with interested parties, I would hope that would be enough to make sure that there are no things that do fall down through the cracks.
Mike, did you want in on that?
No, I think the issues of export.
Indeed. Ansala?
Yes, Chair, thank you. I just want to go back to part one of the discussion earlier in regards to levels of scrutiny, and in particular, Mr. Stevenson brought up the point about cross-border legislation and trade and so on. And I want to take that a stage further. While I'm not looking for a response from you today, because if you've not been able to answer that, you won't be able to answer my point either, because I'm also looking at EEC legislation as well and seeing, are we putting ourselves at risk of somebody taking us to the European Parliament over issues like this? And how do we protect ourselves against that? And levels of scrutiny that are perhaps being missed. So I'd be keen, Chair, to get a response back addressing not only Mr. Stevenson's point, but also the point about European legislation and how that would affect us as well.
Well, I'm sure consistency with European legislation is absolutely a fair question. So does Mr. Burgess want to address that?
Yes. quite a lot. If we look at part 2 of the bill, which deals with environmental matters, that is an area where quite a lot is legislated for at European level. That, I'm afraid, limits the extent to which our ambitions for the simple, streamlined system can actually be realised, because we need to ensure, when we're implementing it, that we have correctly transposed all of our EU obligations. So while we want this flexible system with different tiers of permits, we're limited, for instance, by the Industrial Emissions Directive, which mandates that for certain industrial activities there absolutely must be a permit, and none of the lower levels will suffice. So we do what we can within that framework of European legislation, and there are times when that framework of European legislation isn't itself altogether internally consistent, which causes us some difficulties. I think Mr. Brown might be better able to respond in relation to part 1 of the bill. There are certainly issues around, as I've encountered in another area, around the Services Directive, which sets up rules on how enterprises from one part of the European Union can do business in another part of the European Union.
Again, we're not conscious of there being any issue in relation to the bill as submitted and existing European legislation or requirements. So we're comfortable that that's compatible with EU legislation.
Do you want to?
Chair, sorry. I'm not really comfortable with that response. It doesn't convince me, and I'm quite happy for you to come back to me with some detail on that, because while you're saying you're comfortable with it, I'm not, and that's the reason I'm asking the question.
Right. Well, I'll certainly provide additional
Thank you, Chair.
material.
Okay, thank you. Stuart, yes, okay.
It's just occurred to me on the back of the discussion we've been having that, of course, with guidance being elevated to be a more significant part of the management framework for the policy here, I take it a commitment has been made that all the guidance that will be provided under powers under this Act will actually be published to be available for scrutiny by Parliament, and for Parliament to respond to if it feels that it wishes to do so, even if there is no parliamentary process identified with the guidance.
That's a level of detail that we haven't yet considered. Certainly the Code of Practice, it's included in Part 1, will be published, and as I say, we envisage that there may be a sort of a line of sight or a route for more general ministerial guidance to be absorbed in subsequent versions of that document when published.
Could I suggest, and I do so personally because I have no mandate speaking on behalf of the committee, although I appear to get some nodding heads, that the committee would probably regard it as advisable that ministers make such a commitment to publish guidance.
As I say, up to this point,
This is not the place for
Yes.
you, clearly.
Yeah.
If that is not the current situation, you cannot make that commitment as an official.
Yeah.
But I suggest that perhaps ministers be engaged by you on that.
Thank you.
John Patton.
On the environmental regulation, and Mr. Burgess, you may have already kind of answered in response to Mr. Scott and Mr. Stevens' previous questions. However, the negative procedure applies to the powers to make regulations in Section 10, unless there is a textual amendment of primary legislation when the affirmative procedure applies. Schedule 2 includes some significant powers, such as to create new offences and to impose new fees and charges in paragraphs 28 and 30. Can you explain why it is considered appropriate that the negative procedure should apply, save where primary legislation as amended?
I think if I do so by looking at the history of what happened under the Pollution Prevention and Control Act 1999, which, as I was explaining to Mr. Stevenson, is the predecessor power for a large part of this, and a mixture of affirmative and negative procedure instruments have been made under that power. As I mentioned, the most recent set of regulations to implement the Industrial Emissions Directive at the end of last year was made under affirmative resolution procedure. There's the flexibility in the interpretation of the Legislative Reform Scotland Act that allows the affirmative to be used even if only the negative procedure is mandated. So there is flexibility there to use either affirmative or negative depending on the extent of the subject matter. There are occasions, for instance, when we are required to implement European directives on environmental matters, and the way to do it would be through this power, but for something that, quite frankly, has little or no effect in Scotland. There'll be one coming up very shortly in relation to the storage of metallic mercury, a practice which doesn't happen in Scotland. So there will have to be legislation to meet the European requirements, but it has no practical effect in Scotland. That's the sort of case where I would suggest that negative resolution procedure is perfectly adequate. In others, and I would have certainly thought the first time that we use this power, certainly when we bring in the material from the radioactive substances and the waste regulation, affirmative procedure would be entirely appropriate for that. So affirmative or negative can be used really according to the significance of the instrument.
Thanks, Mr. Bridges, for that. But given the scope of the powers, was consideration given to applying a higher level of scrutiny, the affirmative procedure or even a super affirmative procedure, to the new powers to make environmental regulation which extend beyond the existing powers?
Yes, and as I say, we've looked at the existing powers that we've drawn on, the history of parliamentary scrutiny of those powers, and consider that what's provided in the bill is appropriate for that.
Scott?
Thank you. Take you back to European stuff, and paragraph 22 of Schedule 2 of the bill allows the regulations to make provisions which, subject to any changes which the Scottish ministers consider appropriate, are similar to any provisions capable of being made under the European Communities Act 1972 in connection with EU obligations relating to the environment. Could you explain, please, why this power is appropriate, as the 1972 Act is the general enabling provision which allows the implementation of EU obligations by subordinate legislation?
Again, that power, although it may look a little unusual, is really nothing new. It has a direct predecessor in paragraph 21B of Schedule 1 to the Pollution Prevention and Control Act 1999, and there's another one of a similar nature in the Water Environment and Water Services Scotland Act 2003. So it's essentially not a new power, and it allows, rather than have either separate instruments or to use the powers from two different acts in making the same instrument, which is, as the committee will know, is technically possible. It allows a single set of powers to be used here.
Forgive me, is the advantage of that if you're trying to make a set of regulations, it's easier to have one power in these that enables you to do them all in a one, rather than refer back to the other one for the bit that would be appropriate?
Essentially, yes.
Yep, thank you. That's very helpful.
Given the width of the proposed substantive powers in the bill, can you explain why further powers are required to make supplemental, incidental and consequential powers? And can you give some examples of how these ancillary powers might be used, please?
Which power are you thinking of in particular?
I would need to, in relation to both parts 1 and 2, just ancillary powers. need to ask others which parts we are thinking of.
Yes. Well, looking at in relation to part 2, by way of example, it's certainly very common that regulations under that power need to make consequential amendments out into a whole variety of other bits of legislation. While we might be dealing with environmental protection, references to those environmental protection regulations can frequently be found as far afield as in tax legislation. So there is a need certainly to be able to make that sort of consequential provision.
Forgive me, I'm confused. If you're making regulations which are designed to change things anyway, why would you then need the power to make supplemental provisions to the regulations you've made to change what's there? Isn't what you're doing the change process? Why would you then want to have supplemental stuff to that when your power in the first place is the power to change?
But we need to be able to make those provisions out into other areas of legislation. I think that may be more the consequential than supplemental.
You needed to change another piece of legislation in the process of your regulation. Surely the change to the other bit of legislation should be the next line in the regulation you bring forward. Why would you want to have a power to do something else afterwards, other than because you forgot it the first time round, which is somewhat unkind, but may actually be the point?
But I'm sorry, I think that's exactly what Section 44 provides. It provides the power within our regulation-making powers to make that supplemental, incidental, consequential provision. Without Section 44 there, we wouldn't have the virus to do that.
No, it's all right. I think I'm with you. Yeah, okay. What you're saying is that you need to be able to change the whole of the statute book, and this power enables you to be quite sure that you can do everything that's necessary.
Yes. Without this power, we could make the environmental regulations, but we would not be able to make the changes elsewhere in the statute book where there are cross-references to that. So without that, those other areas of legislation would not necessarily work as they're intended to do. And that, I would suggest, is not a very good thing to allow.
Yeah, I'm with you. Thank you. Okay. Are there any further questions, colleagues? We're comfortable with that. Can I thank you very much for your extensive evidence to us? And I'm going to suggest we have a brief break. So I'll pause the meeting for 5 minutes or so. as we reconvene, this is agenda item 3. This is an opportunity for members to ask questions of the Scottish Government officials on the Children's Hearing Scotland Act 2011 Rehabilitation of Offenders Transitory Provisions Order 2013 SSI 2013-146. And I welcome from the Scottish Government Daniel Kleinberg, John McCutcheon as Policy Officer for Children and Families Directorate. Daniel Kleinberg, of course, is Team Leader for Youth Justice and Social Care. Gordon McNichol is the Divisional Solicitor from the Directorate for Legal Services. And Roddy Flynn, who's a Senior Principal Legal Officer from the Directorate of Legal Services, all from the Scottish Government. Good morning, gentlemen. Thank you very much for waiting patiently. And I believe that Daniel Kleinberg would like to make an opening statement, which I think we'd be grateful for.
Thank you.
Thank you.
This will just take 3 or 4 minutes and respond to some of the points that the committee had suggested you might want to talk about today. The committee will know that the intention had been to lay the relevant secondary legislation necessary to bring the new disclosure regime contained within the Children's Hearing Scotland Act 2011 into effect as part of a wider go-live of a new children's hearing system, and that had been intended to happen on the 24th of June 2013. However, earlier this year, a question about the legislative competence of one of the SSIs, which would have achieved this, emerged as a consequence of officials becoming aware of discussions that had taken place between officials in other parts of the Scottish Government and the Parliament in connection with what is now the Rehabilitation of Offenders Act 1974, Exclusions and Exceptions Scotland Order 2013. As a result of this development, the relevant SSIs have not been laid as planned. Rather, we have a transitory order that we're here to talk about today. The disclosure provisions in the 2011 Act reclassify certain children's hearings disposals from convictions to alternatives to prosecution and provide the Scottish ministers with the power to make an order under the Police Act 97 specifying the offences which Disclosure Scotland can access automatically whilst discharging their functions of providing criminal record checks for recruitment and other purposes. The Police Act order needs to be supplemented by an order under the Rehabilitation of Offenders Act 1974 to ensure that only those individuals with a children's hearings alternative to prosecution in respect of offences set out in the Police Act order, and those will be serious sexual and violent offences, are compelled to tell an employer that they have a spent children's hearings alternative to prosecution. The issue raised by the discussions I've just referred to is a complex one, but in essence, whereas we currently have the powers to legislate generally for disclosure of children's hearings disposals because they are classed as convictions, the effect of decriminalising those disposals and making them equivalent to alternatives to prosecution is that we move into a territory where we do not have the equivalent competence to act insofar as that impacts on reserved areas. And in particular, the issue here is primarily the regulation of particular professions. That therefore requires us to seek an order from the UK Government under the Scotland Act to transfer those functions insofar as they will impact on reserved areas. So the transitory order under the 2011 Act, which you now have before you, is first required to carry forward the existing disclosure provisions in respect of a new children's hearing regime until the powers we need are achieved. We did look at the alternative option of delaying the new children's hearing system, but that would not be desirable because obviously it's only one small part of a really significant overhaul of the entire hearing system, which is teed up to be operational, as I said, from the 24th of June. Further, delaying go-live would not make the process any swifter. It would simply postpone the other improvements achieved under the 2011 Act. Nor is the option of not providing for disclosure of the new compulsory supervision orders acceptable. That could mean and would mean that individuals with serious sexual and violent offending would not be subject to any disclosure. Finally, we also looked at the option of bringing forward provisions only insofar as they did not impact on reserved areas, but we did not do that for 2 reasons. First, the criminal history system and disclosure procedures are extremely complex, and the lead-in time for making changes and being confident of them is quite long. But second, and more critically in this instance, it would be all but impossible to explain clearly to a child the potential impacts of accepting grounds against them might have on their future need for disclosure and self-disclosure, where that depended on the nature and the type of job they were applying for. So we needed to keep the system understandable to children as they go through it. So to that end, the intention is to continue with existing arrangements as they stand in relation to disclosure, acting as soon as possible after the proposed transfer of powers under the Scotland Act to allow for the changes to disclosure procedure envisaged by the 2011 Act. Now, the timescales for that obviously depend upon scheduling and parliamentary decisions taken elsewhere, but we'd be hopeful of moving this along as swiftly as possible. Discussions with Whitehall counterparts are at a very early stage, but our preliminary view is that the nature of what we're trying to achieve is unlikely to meet with any resistance from them. The nature of the changes we're making were subject to official level discussions with the Home Office, as they're seeking to achieve something similar down south following a recent Court of Appeal decision. So that probably means just a confidence in the likely process of a Scotland Act order, but a wait of 6 to 12 months for bringing forward the provisions we'd hope to have in the next couple of months. Thank you.
Right, I'm grateful for that comment. Could you please explain to me what it is that this order is intended to do that actually gets round the problem?
In very simple terms, what it does is keep the exact system as we've got just now as it relates to disclosure in effect for the new supervision orders that are coming in as part of a children's hearings system. So we already have those powers, they're in effect. What we can't do is bring the new powers in as we decriminalise the outcome of the children's hearings disclosures. So effectively it is exactly as it says, a transitory measure to hold it in place until we have the powers that we need.
Is the effect of it then to avoid the decriminalisation?
In the short term, it avoids the decriminalisation, yes. I mean, it keeps the current system which has these
and therefore retains the disposals within the children's hearing system within the powers of the Scottish Parliament.
Exactly right, and retains the disclosure principles for those.
I'm very grateful. Thank you. Stuart.
Just to pick that up and be clear, we've three regimes. The predecessor regime, the one that is going to be transitory that's before us today, and the destination we will reach when all the various issues are hopefully satisfactorily dealt with. I just want to be clear, and of course I don't want to stray, I'm coming to the very edge of policy, and that's not our concern as a committee. But just to be absolutely clear, there is no individual whatsoever who will be adversely affected by the transition from the existing regime to the transitional regime.
To the destination regime?
No, yeah. to the intermediate regime that we're talking about today. There is no one disadvantaged. They are treated the same.
I'll look to colleagues to correct me if I'm wrong here, but in effect, actually, the predecessor regime and the transitory regime are one and the same. The intention of the order is to keep it exactly as it is, so nobody ought to be adversely affected.
I mean, the adverse effect is limited simply to the change is postponed, which is an adverse effect, clearly, for
Precisely
some
right.
people.
Precisely right. It's the enhanced and better regime in the view of the Parliament and my ministers was to bring forward the new regime. Delaying that is frustrating, but necessary.
Now, of course, that is from the point of view of the individuals whose convictions may or may not be disclosed. On the other hand, there are those to whom the disclosure is made. Is there any disadvantage to those to whom disclosure is made by the existence of a transitory regime, or is the answer simply the same?
It ought to be the same, and the advantage as well, I suppose, is that if we didn't have this transitory regime, obviously you wouldn't have those disclosures, we wouldn't be able to apply them, so you would have the very negative effect of people who had as children got criminal convictions that might be very relevant, particularly relating to serious sexual and violent offending, which wouldn't be available to those who are seeking to keep children safe. Sorry.
Just to understand the reason why it's been necessary to postpone, you said earlier this year the virus issue arose. You have had preliminary discussions with Westminster. Can you just actually lay out some of the timescales so we can see what does earlier this year mean, for example?
It means Easter, and forgive me, I forgot exactly when Easter fell.
No,
Yeah.
Do forgive me, I'm not trying to pin down to an exact date, but just to get a greater degree of clarity.
If you forgive me, I forget the date, but it was the day before the Easter weekend, which is what is bound in my memory, because it's the sort of email you'd rather not find on a Thursday afternoon, but there you go. So that's when it became clear that we had a potential virus issue at that stage. The discussions with colleagues down south have taken part obviously since then, but had been ongoing in any case, because as we were looking to change the system up here, they were similarly considering their own system down south and had actually been in touch with us, partly because I think they were thinking about moving in a similar direction themselves.
And have you a sense of when it might be possible to draw this to a conclusion and be ready to put before Parliament new regulations that will take us to the destination?
Effectively, that depends on the procedure of the Scotland Act order, so obviously we're in the hands of both this Parliament and the Parliament down south for that. So, I mean, typically I think that takes 6 to 12 months. We would have been ready for the 24th of June with a new regime. The orders that we would have had have been prepared, and so have the practical arrangements for that. So the intention would be to move as quickly as possible when the power is in place.
Right, so it's a significant transition in terms of the duration it will apply. You've taken one particular approach. Were there any other approaches you considered taking for how you manage the transition in these circumstances?
As I said in my opening statement, we looked at the option of carrying forward either no disclosure, but I mean, that's really not practicable. I mean, delaying the entire system would have achieved no positive benefit at all and just delayed other impacts. Other changes associated with the go-live date. And I think the more complicated one of operating a mixed economy, as I said, of a disclosure regime that brought forward some parts but not insofar as they relate to the reserved areas, would have been far too complicated in an already very complicated area, frankly, for children especially to understand at a difficult point when they're considering whether or not to accept the grounds against them at a children's hearing.
Thank you. I've got to say, I think actually, though we're not here to consider the policy, leaving it the way it was is actually a very simple policy decision, which makes discussion of how you've done it much easier. John Scott, want to continue at this point, please?
Thank you. Well, at the risk of asking questions that you already answered in your statement, and indeed to Stuart Stevenson, could you explain to the committee just very simply how the Scottish Government intends to permanently resolve this competence problem, just for the record?
I mean, we intend to seek an order under the Scotland Act. I don't know if either of my SGLD colleagues want to say a bit more about that.
Yes, I'll do my best to answer this. We're coming from the background of a very convoluted act in terms of the Rehabilitation of Offenders Act, so it makes the background difficult. The intention is to seek an order under the Scotland Act, seeking powers that the Scottish ministers don't already have. As the matter presently stands, the Rehabilitation of Offenders Act sets out a scheme whereby convictions after a while are spent. We have the power to make exceptions to that where those exceptions are thought to be prudent and sensible. For example, we'd want to make sure that exceptions were made regarding entry to a profession which involved the care of children, entry to medical professions, entry to legal professions. So we make exceptions saying, well, the conviction may be spent for one purpose, but it's certainly not going to be spent for this purpose. And that's fine. The difficulty that we faced earlier was that where we sought to make exceptions, and those exceptions bit into reserved areas, we had a difficulty. We didn't have the power. Health professions, for example. We do have the power where convictions are concerned, because we got that power in 2003 in a Scotland Act order. The intention will be to take similar powers in respect of alternatives to prosecution by way of another Scotland Act order, and at that point we're in a position to bring into force sections 187 and 188 of the 2011 Act. Those sections are the sections that bring in the alternatives to prosecution and, in effect, the decriminalisation of this particular area, so that children will no longer be criminalised by a conviction. But some of those alternatives to prosecution will nevertheless still have to be part of a disclosure, serious, violent and serious sexual offences. So, in effect, it's a patch until we get those powers.
Thank you. And in terms of the discussions with the UK government, and the transfer of competence to enable the Scottish Government to make exceptions from the Rehabilitation Act. How far progressed are those discussions? I think you probably covered that already, yeah. So I think that's really all my questions have been asked already.
Thank you, John. I'm just wondering if I could just push you gentlemen on. I understand that it takes a while to do things. I mean, yeah, I think we all know that, but why does it take a year to do something we know precisely what we want to do?
Simply because of the procedures required in order to achieve the Scotland Act order. I mean, I hope and our expectation would be that we will talk to the UK government and ask them to make representations in turn to the Parliament to schedule this as quickly as makes sense. But that's what we're dependent on.
I think what we would say is experience tends to show that Scotland Act orders can appear deceptively simple, but they just invariably take a long time, or significantly longer than you might hope, to pass through the system.
Yep. Thank you, and I'm grateful. There's no point in pretending something is going to happen in a hurry if history tells us it isn't.
Indeed.
It's just sometimes extraordinarily frustrating to we think we know what we need to do, why can't we just do it? And that's the way it is. Hansala.
Thank you very much, Chair. I just at the back of that question, I just wanted to ask, in terms of European legislation, I take it there's no danger of us falling foul of any European legislation in terms of what we're trying to achieve.
No. I mean, I think if there was to be an issue, and I stress the word if because I don't believe there is. Right. I think more in terms of ECHR, but there are no ECHR issues here because, in fact, what we're seeking to do, as Daniel said, is continue the existing regime at the moment, which we are satisfied is ECHR compliant, with a view to moving to a regime which decriminalises activity, and so, if anything, is less challenging in terms of ECHR. But having raised that point, I'm only raising it to say I don't think there is a problem, no.
Right. Okay. Thank you, Chair.
Again, forgive me, Chair, if this question's already been answered. It's with regards to Mr. Flynn, you spoke earlier there about the effect of changing the treatment of disposals from convictions to alternatives to prosecution as regards devolved matters separately from reserved matters. Now, why therefore has the Scottish Government elected to postpone the transfer to the new arrangements for devolved matters as well as reserved matters?
Not perhaps. Simply for grounds of simplicity. I mean, that it would have been extremely technically difficult to achieve just because of the complexity of it, and in doing that, that would have led to procedure changes at quite short notice to a system that maybe would not have been able to achieve those. But as I said in my opening statement, that was one reason. But the primary reason is actually being able to explain to children at the time what the arrangements in the future will be, what they will in the future have to disclose about their previous behaviour, and the complexity of saying to them, and if you're applying for this profession in that context, you'll have to say you did this, but not if you did that. The complexity of that is just such that it's far preferable to be able to say to them, here's what you'll have to disclose in the future and here's not, and make it quite clear and determined by offences rather than future context.
Okay, fair enough. Thank you. Mike, do you want to look at one, two details, please?
Yes,
Thank you.
Question, just a slightly different area. In the written reply from the Scottish Government Legal Directorate to the committee on this instrument, it's acknowledged there are errors in Article 24A2 of the order, as certain references to provision in the 2011 Act have no effect. Could this cause confusion to readers? It certainly has done to this reader and those who will operate these provisions.
I think the technical answers cause a bit of confusion to me for a couple of hours, but John can maybe strike a bit of clarity here.
Well, I think the two provisions that you've actually mentioned, the effect is there's no acceptance or establishment of the offence grounds. So in effect, the provisions of the Rehabilitation of Offenders Act are not engaged. So those provisions don't apply. Because at the moment, the acceptance or establishment of a referral on offence grounds is classed as a conviction. But in the two circumstances in 94.2b and 1143b, they relate to circumstances where in 94.2b the ground was not understood, and in 1143b it specifically relates to a circumstance where the offence ground has been discharged. So neither of those instances bring in the Rehabilitation of Offenders Act.
Sure, but you accept that that could cause confusion?
I think it would be confusing in terms of trying to understand exactly how the order operates and works, which is why we tidy it up in the future. In practice, because the 74 Act, as I understand it, wouldn't be engaged, no children will find themselves actually being affected by that. So it's right to tidy it up, but that's more one of neatness than
so
operation.
They'll be confused but not affected.
Yeah.
But that brings me to the next part of my question, really, and it's, you know, the Scottish Government have given an undertaking, obviously, to amend the order to remove these references, using that often used phrase, "at the next available opportunity." Could you give us an idea about when that might be?
I'll turn to SGLB.
Yes, as you say, amendment at the next available opportunities is a kind of standard form of words. I think what we would have to say is, ideally, you would want to tidy it up when we're next making changes. Excuse me. Anyway, that may prove not to be possible because there are no changes envisaged. So it's the short answer, I think, is we can't say yet when it will be done, because the next available opportunity, at the moment, by definition, we do not know when that will be. If the view is taken that this is causing concern or causing difficulty, excuse me, then it may be that a bespoke instrument to make the changes will be required. Or if it's not clear that there will be a next available opportunity, if you like, in the reasonably foreseeable future, we'll have to take it forward separately. So the short answer, I'm afraid, is no. Don't know yet, but it will be kept under review, and we tidy it up as soon as we can reasonably do it.
Okay, thank you.
John, you may be going to express the same view.
The same thing, but given, as I used to say about, what was it, some discussions, you know, if you're not confused, you haven't been listening, and given the confusion that already surrounds this legislation, would it not be in everyone's best interest just to produce a complete and fully accurate bill, which is really what you intend in the first instance and at this time?
I think having had the issue raised in the committee's response very helpfully, I think what we'll want to do is stress test our assumption that nobody could be affected by this. And if the truth is that nobody would be affected by it, I think the tidying up of the draft order, given that it will have a short time life on it in any way of between 6 and 12 months, doing something bespoke and making demands of government and parliamentary time for that, I think, would be something we'd think about quite carefully. If people were potentially going to be affected, or there was feedback from colleagues who deal, say, SCRA and the Children's Reporter Administration, that this could be causing concern even amongst those not affected, we'd obviously probably want to move more quickly. So
essentially over time, then the need for this becomes redundant.
Yes, because it's a transitory order, therefore it's of limited life, depending on the UK governments.
Thank you. I think you will have got the message, and I think one of our main concerns as a committee is that what comes before us should be correct. You know, and when you find things that are simply wrong and everybody knows it's wrong and it shouldn't be there, then it is extremely unsatisfactory to us as a parliamentary committee to find that folk are, for understandable reasons, saying, well, we're not going to change it. You know, I mean, if you were able to say that every copy that would go out would have a red pen through this saying this doesn't apply, take it away, that would be fine. But of course you can't do that, and obviously any version on the net, again, you just can't do that to it. I think that's actually what we really want you to do. So we would prefer that the legislation was correct, please, subordinate or otherwise. Okay, I think with that, I'm looking around, I think we've probably finished, and I can thank you very much for your evidence, and we'll suspend just briefly while you're able to go. I've only got a page to read, you shouldn't be. We can simply reconvene. I think we've reached agenda item 4, which is instruments subject to affirmative procedure. Mobile Homes Act 1983, amendment of Schedule 1, Scotland Order 2013 draft. Paragraph 19 is intended only to permit a review of pitch fee for a mobile home after the review date if no review took place at the review date. However, paragraph 19 does not restrict subsequent reviews to circumstances where a review did not take place on that date. The government accepts that this provision could be more clearly drafted to reflect their intention. Does the committee agree to draw the instrument to the Parliament's attention under reporting ground H as the drafting of paragraph 19 to be inserted into part 1 of Schedule 1 to the Mobile Homes Act 1983 could be clearer?
Agreed.
Sure.
I would just say, I mean, from my understanding of it, this might require people to go to court to eventually seek and find clarification, and I'm not certain, therefore, it is sufficient for the government to say that the provision could be more clearly drafted to have reflected their intention and that this will be resolvable in court. I would prefer if the original instrument were drafted in such a way that didn't necessarily put people to that expense.
We are agreed nonetheless to draw it to the Parliament's attention. Thank you. No points have been raised by our legal advisers on the Sexual Offences Act 2003 notification requirements, Scotland Regulations 2013 draft. Is the committee content with that instrument, please? Thank you. Takes us to agenda item 5, instruments subject to negative procedure. No points have been raised by our legal advisers on the Home Energy Assistance Scheme, Scotland Regulations 2013, SSI 2013-148. Is the committee content with that instrument, please? We are. Thank you very much. That brings us to agenda item 6, which we move to private. Thank you.